Edvision, your one-stop learning solution and key to success. Please like, share, subscribe our channel and click the bell icon to get notified whenever we upload a new video. Edvision is registered under MSME Government of India and also certified to ISO. Today's topic is Hindu Marriage Act Part 1. Marriage has been considered as the greatest and the most important of all the social institutions. For the Hindus, it is considered as a means to lay the foundation for building up the family, which is the basic unit of any society. A Hindu marriage is also known as Vivaha, which is the traditional wedding ceremonies for the Hindus. The word Vivaha originated as a sacred union of people as per the Vedic traditions. Under Vedic Hindu traditions, marriage is viewed as one of the samskaras. Since marriage holds such a great significance in the society, it is necessary for the legislature to come up with the proper legislation which deals with the governance of marriages in the country. Therefore, the Hindu Marriage Act 1955 was enacted to amend and codify the laws relating to Hindu marriages. It has not only reformed and codified the Hindu marriage law, but also introduced certain important changes in many respects. The Hindu Marriage Act 1955 came into force with the objective to secure and protect the right to marriage of the Hindu men and women. In India, the right to marriage has not been explicitly provided anywhere, although its essence can be found in Article 21 of the Indian Constitution. The Hindu Marriage Act 1955 regulates the institution of marriage of the Hindus in Indian society. It prohibits meaning to marriage, cohabiting rights of both the bride and the groom, and a safety to their family and children. The Hindu Marriage Act 1955 has 6 chapters which contain the sections: preliminary with section 1 to 4, Hindu marriages section 5 to 8, restitution of conjugal rights and judicial separation section 9-10, nullity of marriage and divorce section 11 to 18, jurisdiction and procedures section 19 to 28, savings and repels section 29 and 30. So there are total 30 sections in Hindu Marriage Act 1955. This episode we will discuss about the chapter preliminary, which has 4 sections Number 1, short title and extent. Section 2, application of Act. Section 3, definitions. And Section 4, overriding effect of Act. In the next 5 episodes, we will be discussing about the next 5 chapters of the Hindu Marriage Act. Section 1, short title and extent. The Hindu Marriage Act is an act of the Parliament of India enacted in 1955, which was passed on 18th of May. This act may be called the Hindu Marriage Act 1955. It extends to the whole of India except the state of Jammu and Kashmir and applies also to Hindus domiciled in the territories to which this act extends who are outside the said territories. That means people living in other countries are also considered under this Hindu Marriage Act if they are belonging to the Hindu religion. Purpose. The main purpose of the Act was to amend and codify the law relating to marriage among Hindus and others. Besides amending and codifying Shastric law, it also included separation and divorce, which also exist in Shastric law. This enactment brought uniformity of law for all sections of Hindus. In India, there are religion-specific civil codes that separately govern adherents of certain other religions. Section 2, applicability. Section 2 of the Hindu Marriage Act 1955 says, this act implies to any person who is a Hindu by religion in any of its forms or developments, including a Virashaiva, a Lingayat, or a follower of the Brahma, Prarthana, or Arya Samaj, to any person who is a Buddhist, Jain, or Sikh by religions. This section therefore applies to Hindus by religion in any of its forms and Hindus within the extended meaning too. To any other person domiciled in the territories to which this act extends, who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that any such person would not have been governed by the Hindu law or by any custom or usage as part of that law in respect of any of the matters dealt with herein, if this act had not been passed. Explanation. The following persons are Hindus, Buddhists, Jainas, and Sikhs by religions as the case may be. A. Any child, legitimate or illegitimate, both of whose parents are Hindus, Buddhists, Jainas, or Sikhs by religion. B. Any child, legitimate or illegitimate, one of whose parents is a Hindu, Buddhist, Jaina, or Sikh by religion, and who is brought up as a member of the tribe community, group or family to which such parent belongs or belonged, and C. any person who is a convert or reconvert to the Hindu, Buddhist, Jaina or Sikh religion. Notwithstanding anything contained in subsection 1, nothing contained in this Act shall apply to the members of any scheduled tribe within the meaning of Clause 25 of Article 366 of the Constitution unless the central government by notification in the official gazette otherwise directs. The expression Hindu in any portion of this Act shall be construed as if it included a person who, though not a Hindu by religion, is nevertheless a person to whom this Act applies by virtue of the provisions contained in this section. The Act was viewed as conservative because it applied to any person who is Hindu by religion in any of its forms, yet groups other religions into the Act, like Jainas, Buddhists or Sikhs, as specified in Article 44 of the Indian Constitution. However, with the passage of Anand Marriage Amendment Bill in 2012, Sikhs now have their own personal law related to marriage. Section 3 Definitions. In this Act, unless the context otherwise requires, the expressions custom and usage signify any rule which, having been continuously and uniformly observed for a long time, has obtained the force of law among Hindus in any local area, tribe, community, group or family, provided that the rule is certain and not unreasonable or opposed to public policy, and provided further that in the case of a rule applicable only to a family, it has not been discontinued by the family. B. District Court means in any area for which there is a city civil court, that court, and in any other area the principal civil court or original jurisdiction, and includes any other civil court which may be specified by the state government by notification in the official gazette as having jurisdiction in respect of matters dealt within this Act. See full blood and half blood. Two persons are said to be related to each other by full blood when they are descended from a common ancestor by the same wife, and by half blood when they are descended from a common ancestor but by different wives. Let us now discuss elaborately about half-blood. Suppose the husband A with wife B has their children, one child C. After the wife B's death, husband remarries wife D and they have a child E. So C and E will be related as half-blood. They both have same father but different mothers. Number D, uterine blood. Two persons are said to be related to each other by uterine blood when they are descended from a common ancestress but by different husbands. Let us explain elaborately about uterine blood. Suppose wife B has a husband A and they have a child C. After death of the husband A, wife B remarries husband D and they have another child E. So E and C will be related as uterine blood to each other. That means they have same mother but different fathers. Explanation. In clauses C and D, ancestor includes the father and ancestress the mother. E, prescribed, means prescribed by rules made under this act. F, sappinder relationship with reference to any person extends as far as the third generation inclusive in the line of ascent through the mother and the fifth inclusive in the line of ascent through the father, the line being traced upwards in each case from the person concerned who is to be counted as the first generation. That means sappinder relationships are extended relationships through generations, such as father, grandfather, great-grandfather, like this. Common ancestors, father or mother, grandfather or grandmother, great-grandfather or great-grandmother, like this. Two persons are said to be sappinder of each other if one is a lineal ascendant of the other within the limits of sappinder relationship, or if they have a common lineal ascendant who is within the limits of sappinder relationship with reference to each of them. According to old Hindu law, when two persons offer pinda to same ancestors, then it is said that they are in a sappinder relationship. Degrees of prohibited relationship. Two persons are said to be within the degrees of prohibited relationship if one is a lineal ascendant of the other, or if one has the wife or husband of a lineal ascendant or descendant of the other, or if one was the wife of the brother or of the father's or mother's brother, or of the grandfather's or grandmother's brother, or of the other, or if the two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister, or of two brothers or of two sisters. Explanation. For the purpose of clauses F and G, relationship includes relationship by half or uterine blood as well as by full blood, illegitimate blood relationship as well as legitimate, relationship by adoption as well as by blood, and all terms of relationship in those clauses shall be construed accordingly. Section 4. Overriding effect of Act. Save as otherwise expressly provided in this Act, a. Any text, rule or interpretation of Hindu law or any custom or usage as part of that law in force immediately before the commencement of this Act shall cease to have effect with respect to any matter for which provision is made in this Act. B. Any other law in force immediately before the commencement of this Act shall cease to have effect in so far as it is inconsistent with any of the provisions contained in this Act. That is all about the preliminary section.